Okay, so welcome, welcome, welcome. I do appreciate every single last one of you all for being here. I'm very excited about this workshop. I hope you guys are as well. Guys, when it comes to credit, absolutely love it, love it, love it. And the reason why I love credit so much is because of the lives that I'm able to change by being in this industry. So I'm going to say this statement one more time before I move on to the next slide, which is if you want to follow along with me while we're going through looking at these different types of accounts, make sure you pull your credit reports from annualcreditreport.com to follow along. So, welcome to the How to Clear Credit Workshop. I'm very honored to have you here. Thank you for your time because I know that you guys could have been anywhere else. I know it's the holiday weekend, and so a lot of people are out hanging with their family and things like that, but you guys chose to be here, so I'm very grateful for that. So let's go ahead. Hi, thank you so much for being here. So, in case you don't know who I am, or in case you're kind of new to who I am, I just want to give a little brief. Hold on one second. People are joining in. So, my name is Diamond. I've been in this industry for a little over 4 years now. When I first started I was taking clients, and I made enough to quit my job and focus solely on taking care of individuals with credit issues. So, when I came into this industry, I was at a point in my life, for one, I was a mom of two kids. My little man, he was just born, and I was like, on one side, I was like, I really don't want to be back at work and struggling and all that again. And on the other side, I was like, I really want to get into business where I'm able to help a lot of people. And credit, the opportunity to learn credit and open a credit business was presented to me. And since then, I have been taking it off. It's been amazing. So I quickly learned that there was more to credit than what I knew. And so I became obsessed with learning how to help people with credit and learn how to help them get rid of those balances. Since I have been obsessed with this thing, y'all, I've helped thousands of people. Now, I know a lot of you guys that are on here kind of transitioned over with me because I had a old page, and that page had so many followers and had most of my clientele on that page. I opened a new page, and so it's kind of just lost in the sauce. But since I've started teaching credit, since I've started mentoring people with credit, I have helped thousands of people. So I've helped them put money in their pockets. I've helped CROs help their own clients eliminate them debts. And then I've also helped people just clear up their credit, help their family, and so on and so forth. So for me, I love teaching because I'm able to help more people on a grander scale. And that's what I love doing. So so just a little bit of a introduction to me today. So for today, we're going to be doing, we just got over the introduction. We're going to talk about credit myths, which are very important, the credit laws, which are also very important. We're going to have a break. We're going to get into how to handle negative accounts, and then we're going to go over your next steps that you need to take. If you are at a point where you follow these steps, you got a response. So then trying to figure out what to do. So I'm going to tell you exactly what you need to do in order for you to keep going with your process, okay? So you're not going to leave here at all thinking, well, dang, I don't know what to do next. You're going to have what you need because this is the point of this workshop. It's for me to give you what you need. You go ahead, you implement, you execute, and then you're able to pass on the information. You're able to get the results that you want to get and all that jazz, okay? So common credit myths. I feel like this is very important because social media is just constantly is getting bigger. It's constantly growing. And I feel like that the things that I've been seeing, especially on TikTok, it has to be addressed. So I want to go ahead and just make these things clear to you. These are myths. These are not accurate. All right. So the first myth, you don't have to provide proof of inaccuracy. So what that means is you can just send a bare bone letter saying that this thing is inaccurate, please investigate it and send me the results, and that's good enough. I'm here to tell you that it's not good enough. And I'm speaking from experience, and I'm also speaking from knowledge on the fact that I've been on the opposite side where I have how do I want to say that? I filed court cases, right? So I've been in court. I've also, because I've been in court, I've had to study other court cases that have happened as it relates to credit. There are so many cases that are filed from people who believe these credit myths I'm about to address today, and they are dismissed. So the pro se, which is people who are representing themselves without a lawyer, they are embarrassing themselves, and they are making it hard for people like us who are wanting to learn the real information, go out and be successful with this. I say all that to say, the cases that I have researched and have looked into, the judges are always saying that you have to provide the proof of whatever you are disputing in order for you to have a very solid and strong foundation. So in this workshop, I'm going to be giving you all a very strong and solid foundation, okay? Another credit myth: you can clear your credit in 7 days. Now, the reason why I say this is a myth, I know that people are able to get results in 7 days. I have seen it before. I say this is a myth because people who are advertising these kind of results are the same people who are doing credit sweeps. Credit sweeps are extremely illegal, and they will put you in an even worse position than you already were. I'm also telling you this from experience because I used to be in a lot of different credit groups and tax groups, and those things go hand in hand. If you know, you know, right? And so people would be complaining about how, they had signed up with someone and that someone promised them to get results in 7 to 14 days. And then now they got the feds knocking at their door because of what was done on their behalf. And unfortunately, they're unable to escape that because they signed off on them doing whatever they did. So my thing would be, I understand that a lot of us are in, very detrimental situations sometimes. I understand that we're desperate for results. But a true credit repair agent, someone who is truly following the laws and all the things that come with it, it's going to take at least 4 to 6 months. And that's being generous with the responses. Now, I've seen results from my clients when I used to take clients 30 days. Students have seen results in 14 days, but they were not doing credit sweeps. So I'm just going to stop there. Okay. Another common credit myth: debt collectors can't report on your credit. That is also not true. They have the right to report on your credit, and I'm going to go more into this later on in the class, in the workshop, when we are talking about how to handle collection accounts. So we're going to get more into that. But debt collectors can report on your credit if they are following the law. Excuse me. Let me also add in this, guys. For some reason, my body decided that today was a perfect day to be sick. I woke up this morning, throat hurting. I've been sneezing. So I have halls here. I have water here. So if you guys hear me doing all that, or I'm mute really quickly, it's for that. I apologize in advance. I don't know where it came from, but I just felt that, I'll let you guys know. I do feel really like I'm getting sick quickly. And so I'm pushing through though. I'm here for y'all. Let me say somewhere in the chat. Thank you so much, Sarah. I really appreciate you. So are you guys following me so far? Because for me, I can just talk all day, especially when it comes to credit. But let me know in the chat. Don't unmute. Just let me know in the chat if you guys are following me. Okay, perfect. All right. So another myth that's been going around, it's been very popular. The agencies need your consent to report anything on your credit. Now, I will be transparent and tell you guys that at one point I was also moving with this idea in my mind because I was following misinterpretations. I was listening, and it just felt good to believe that something way bigger than what I was aware of was coming against me. All right. So this is not true. All right. The reason why it's not true is because I can tell you for a fact that most, if not all of those accounts that you have signed up to use, whether it's credit cards, your bank accounts, and personal loans, all those different things, they all say that they're going to be reporting the activity on your account to the agencies, and they call them credit bureaus, so to the credit bureaus. They all say that. But because we were so excited about getting the thing, whatever that thing was, we did not read the terms and conditions. So now you're learning about these things with credit, and people are out here spreading false information to get you to pay them some money. Now you're believing, oh, well, yeah, they need my consent. I didn't give them my consent. All actuality, you did give them your consent. You did. And it's okay, but that's just the reality of it. All right. So now, the law. This is a part. Now, the first part of this workshop is going to be, some people may consider to be boring. And it's very important that I discuss these things because in order for you guys to be successful with what I'm going to be showing you guys how to do, you have to understand why we are doing it. If you don't understand why you're doing what you're doing, you are not going to be successful because you're going to get into a point where maybe you're being questioned. You're not able to explain anything. I don't want you all to be in that position. So for me as your teacher, I'm going to explain why we are doing this, what law backs this up, so that you are moving confidently when you are helping other people or just helping yourself. Okay. So understand that the reason you're able to get things removed is because of the laws that are in place, which are the Fair Credit Reporting Act, aka FCRA, and the Fair Debt Collection Practices Act, aka FDCPA. Okay. So, common definitions. Shell, you're going to see this a lot when you decide to, geek out, like kind of how I did, right? When I started learning this, I was like, oh yeah, I got to study. And so I became a real huge nerd when it came to credit. You're going to see throughout the laws that they are listing these things. And I just want you to know in layman's terms what these things mean. So shall means must, it's required, it's not optional. There's not a choice. This is what has to be done, and there's no other option. So consumer reporting agencies, they are also called credit bureaus. They are also called credit reporting agencies. Nowhere in the law, however, are you going to find them being referred to as that. The technical term for Experian, TransUnion, and Equifax is consumer reporting agencies. That's it. All right. So you're also going to see furnitures or persons, right? Person are the companies, furnitures are the companies who are reporting our account information to Equifax, TransUnion, and Experian. So Capital One, Citibank, Navy Federal, those are all considered to be furnitures or persons. So consumers, you and I, we're consumer people, everyday living people who purchase things, who apply for things, we're consumers. Debt collectors. Debt collectors are not everybody, all right? Despite what has been going around on social media streets, everybody are not debt collectors. In fact, debt collectors are only companies who have acquired your past due account from another party. So the key word is past due. Keywords are past due. So if anybody has, let's say that a company went out of business, right? And so your account information was transferred to another company and you have to now make payments to them. That person is not a debt collector if you were current on your account once they acquired it from the first party. They only become a debt collector once that account is in default. So if you were past due, it doesn't matter if it was 30 days. 30 days late and they got your account, they are now considered to be a debt collector. Okay. So let's get right into it. The Fair Credit Reporting Act, 15 USC 1681. So what we're going to be doing is we're going to be talking about the purpose, the reason why this act was even created in the first place. Remember, this is to help us with the why we're able to do what we're able to do with our credit reports. So it is the purpose of this subchapter to require that consumer reporting agencies adopt reasonable procedures. Oh my gosh. Okay, sorry, y'all. Whew. I low-key forgot that I was recording, so I thought that I was talking all this time, but they record. Okay, sorry about that. Let me start back over. It is the purpose of the subchapter that to require that consumer reporting agencies adopt reasonable procedures for meeting the needs of commerce for consumer credit, personnel, insurance, and other information in a manner which is fair and equitable. Second. All right, great. Make sure you guys are muted, please. I appreciate you guys for being here. Which is fair and equitable to the consumer with regard to the confidentiality, accuracy, relevancy, and proper utilization of such information in accordance with the requirements of this subchapter. So basically, what this is saying is, excuse me. What this is saying is, they created this chapter, they created the FCRA to protect us. And how they're protecting us is they are requiring for the consumer reporting agencies, also known as the CRAs, also known as Experian, Equifax, and TransUnion, they are requiring for them to meet the needs of consumer credit, personnel, and insurance in a way that is fair and equitable to us. So it should be, information should be confidential. And when we say confidential, I know that that normally is meaning private, but our information should be private in a sense where everybody and their grandmom shouldn't be able to access it. So unless they have our personal information, they're not able to pull our credit reports. Now, obviously, we know this isn't true for the businesses that we do business with, or for people who we have applied to get accounts with, or even for the little slip ups that happen, you know, with mixing our credit accounts. But for the most part, our information should be private to the people we have given permission to access it. Our information should also be accurate, and it should be relevant to the current reporting that is displayed. It should also be utilized appropriately. So if these things are not happening, which 95% of the time is not, then we have the ability to go after somebody to get recourse. Are you following, y'all? That making sense? Just put it in the comments for me. And let me know where you guys are joining from. What state are you guys in? I'm currently right now in Atlanta. I do not live in Atlanta, but I'm currently in Atlanta right now. Florida, okay, ATL. Indiana. Okay, perfect. Cleveland. Oh. All right, cool. So amazing. You guys are all over the US. All right, so now we're going to be getting into the common statutes that are currently always violated. These are also the same laws that are used to support us when we are going out and we're trying to hold these different consumer reporting agencies to the fire. So the first one that is very common is going after them under 15 USC 1681 EB. Now, I want you guys to also think about the fact that there are a ton of laws under the FCRA. However, there are only specific laws that you all are able to use to get a remedy with. And when I say remedy, I mean, let's say that you get to the point where you have done your disputing. You are very clear in your letters. You've done your part, but they are still not doing theirs. These different statutes that I'm going to be going over in this workshop are the statutes that you'll use in order to help you be able to generate some money against them. Like, now my suggestion would be for you all to find someone who is well versed in this information, especially if you're not comfortable with doing it. So, and maybe a consumer rights attorney, a consumer protection attorney. But this is how you're able to get them to do what you want them to do. All right. If you have to escalate it. Now, it is obviously our hopes that we don't have to get that far. And I've had great success without having to get that far, but I've also had to go that far and have had success as well. Okay. So this is one of the laws that you can attack Equifax Trade Union or Experian under and get them to do what you want them to do. So whenever a consumer reporting agency prepares a consumer report, it shall follow reasonable procedures to ensure maximum possible accuracy of the information concerning the individual about whom the report relates. So when they are putting our reports together, every single month or whenever you decide to pull your credit reports, they should have procedures in place, because keep in mind that these companies are extremely big. So it's not one person doing everything, right? They should have procedures in place to assure that every single report that is created about us are at the maximum possible accuracy that it could be. Now, obviously, if you have never disputed, if you have never brought to their attention that there is an issue, they have no reason to assume or to know that the information is inaccurate. So as far as they're concerned, before hearing from you, they have been doing just that. So it is your responsibility to, when you have, my nose does this thing, guys, when I'm talking or teaching, my nose like itch, like my skin on my nose itches. I don't. So anyways, if you don't say anything to these agencies about your report, they have no reason, there's no indication that what they have is inaccurate. So it's up to you to let them know and bring it to their attention. Okay. All right. The next statute, 15 USC 1681 IA. Reinvestigations of disputed information. If the completeness or accuracies of any item of information contained in a consumer's file at a consumer reporting agency is disputed by the consumer, not by a third party, not by a credit repair organization, by the consumer. And the consumer notifies the agency directly or indirectly through a reseller of such dispute, the agency shall, free of charge, conduct a reasonable reinvestigation to determine whether the disputed information is inaccurate and record the current status of the disputed information, or delete the item from the file in accordance with paragraph 5 before the end of the 30-day period beginning on the date on which the agency receives a notice of dispute from the consumer or reseller. Now, the resellers are like people who are companies that resell the reports to other companies. So those are, the possibilities are endless for them. But I wanted to put emphasis on the consumer because I have seen Now, I know that there are a few guys who are credit repair organizations and you guys help other people. So this is not me coming at you. This is me bringing some awareness to you. If you are currently, this is a gem too, y'all, because y'all know I be looking out, right? So if you are currently helping a consumer clear their credit, my suggestion would be for you to generate the letter and have them mail it out from wherever they're located. The reason why is because, especially with the uptick with using AI, these companies are coming back more frequently and telling your clients that they feel that their dispute has been created by a third party. And so they're refusing to do the investigation because of their suspicion. So in order for you to kind of get away from having your client go through that, go ahead, draft the letter, send it to them, have them mail it out from there, wherever they're located, just to help avoid it. Now, I'm not going to say that it's going to be guaranteed that you'll avoid it, because the agencies, they just do whatever they want to do. But it is an extra layer of protection for you guys who are doing, taking care of people's credit for them. They have, as you can see, every right to decline to do an investigation if it was not disputed by the consumer. So I want you all to think about that as you are looking and helping other people, whether it's your family or people that you are charging for the service. Okay. So, quick Q&A. Who should you notify if you have something to dispute on your credit report? Let me know in the comments or in the chat. CRA, perfect. So I had to make sure that I asked you all that question because there is a lot of information that is going around where people are being told to send their disputes to the furnishers. And so, as you can see, by me reading the law to you all, you have to send it to the agencies directly. Don't send it to nobody else. All right. So now so the first half was talking about what the agencies need to do. Now we're getting into the furnishers. And who are the furnishers again, guys? Let me know in the chat. Just name off like an example of a furniture, just so I can know that you all are following me. Airbnb, not Experian. Mainland, a federal, yep. Perfect. So anybody who is reporting the information to the CRAs. So y'all were on the money with debt collectors, y'all were on the money with Navy Federal, like anybody, it doesn't matter who it is. Whoever you guys see, when you pull your credit report, you see their names on it, they're furnishers. All right. So the law that governs them. So let's say that you have found some things, you located some stuff, and you sent your letter off. In the event that your stuff is not being handled correctly, right? They're not doing the dispute correctly. They're not resolving your issues. Things are still reporting inaccurately. The furnishers are liable as well. So this is the law that governs the furnishers, and that says you guys need to do this thing. If not, you have violated your responsibilities under this law. Okay. So 15 USC 1681 S2B. Duties of furnishers of information upon notice of dispute. So if you are drafting a dispute letter, you might want to title it Notice of Dispute. Just saying, all right? So after receiving notice pursuant to section 1681 IA2, this is telling you guys already off rip that The letter you send to the CRAs are supposed to be received by the furnishers. So you don't have a responsibility to send the furnishers anything because Equifax, TransUnion, and Experian are supposed to do that for you. And this is telling you, the law is saying this right here. All right. So, of a dispute with regards to the completeness or accuracy of any information provided by a person to a consumer reporting agency. Now, let's go back to the definition. Remember, I told you guys that person also was referring to furnishers. All right. So, a person is not like you and I, because you and I are referred to as consumers in this law. Instead, a person is the business that is reporting your information to Equifax, TransUnion, and Experian. Also, your notice of dispute needs to contain that you are disputing the completeness or accuracy. It says it right here. Okay, so you want to make sure that you are including that in your language in your letter. Now, I'm gonna go ahead and let you guys know that in this workshop, I'm going to be drafting a letter with you all live. So you're going to be able to see exactly what you should be reporting or what you should be saying in your letters. I'm also, as a bonus, going to be giving you all kind of like a guidance. We don't call them templates, right? We call them guides. A guidance on how your dispute letters should be drafted so that you can just kind of plug and play your information, change up a little bit of the wording to fit the situation that's going on with whatever you're doing, and you can send it off like that. Okay, so that's just my thank you to you all for being here. Everyone is going to get that. I really, really appreciate all of y'all being here. Okay, so the person, the company shall do these 3 things. Actually, I think it's 5 things. So we're going to kind of go into that. Excuse me, sorry, y'all. They shall conduct an investigation with respect to this disputed information. So right here is telling y'all that, let's just go with Capital One, right? When you do a dispute, let's say you have a Capital One account on your Experian report, you are sending your disputes about Capital One to Experian. Experian is sending that information, that disputes, your evidence you sent to them, your identifying information to them, all that is going directly to Capital One. Capital One now has an obligation to do their own investigation of the disputed information that you provided in that letter. So not only does Equifax, TransUnion, and Experian have to do an investigation, so do Capital One. All right. And this is telling you guys right here, what's up? This is why I said before I got into this that everybody is liable. The CRAs are liable, and so are the furnishers. Okay. They are, so they shall, remember that shall thing is a requirement, not an option, right? They shall review all relevant information provided by the Consumer Reporting Agency, all relevant information being whatever documents you sent to support your position, that should also be sent to them by the agency, pursuant to Section 1681 IA2 of this title. All right, C, they should report the results of the investigation to the CRA. So the CRA notify them of the dispute, provide them all the information that you sent to them, and then now, after their investigation has been completed, they have to let the CRA know what was found. We're going to continue this. D, if the investigation finds that the information is incomplete or inaccurate, they are to report those results to all other consumer reporting agencies to which the person furnished the information and that compile and maintain files on consumers on a nationwide basis. So not only are they supposed to let Experian, so back to the example, not only is Capital One supposed to let Experian know, but if Capital One is also giving information to TransUnion or Equifax, they need to let them know as well that the information is incomplete or inaccurate. And so here goes a domino effect. So not only are you getting your Experian removed, if that's the outcome of it, but then it should also be removed from Equifax and TransUnion. And there are a lot of other agencies, which is why it says to all other consumer reporting agencies. So there are agencies for literally every single thing you could think of. Our insurance companies, the rental agencies that we apply for, they use their own type of CRAs. You got background checks. You have criminal records. All of those are considered to be consumer reporting agencies, y'all. So when I say that, if your information as it relates to the Capital One account is being reported to all those different kind of agencies, then that needs to be updated with them as well. Are you guys following me so far? Are we good? Drop a diamond in the chat for diamond, or drop a fire emoji, something. Let me know that you guys are following me. Thank you, thank you, thank you. Perfect. Perfect, perfect, perfect. All right, so let's get into, hold on one second. All right, perfect. E, if an item of information disputed by a consumer is found to be inaccurate or incomplete or cannot be verified after any reinvestigation under paragraph 1 for purposes of reporting to a consumer reporting agency only as appropriate, based on the results of the reinvestigation promptly, they should modify that item of information, delete the item of information, or permanently block the reporting of that item of information. Now, nowhere in here do y'all see that they're supposed to ignore you. There is nothing that I went over so far that says that if anything is found to be inaccurate or incomplete or not verified, that you don't know anything. Nothing. So I'm mentioning this because I have heard, and I have also experienced, where you set off an investigation, a dispute, and they respond or they don't respond, or they completely ignore what you've said and they send you a stall letter. Based on what the law says here, nothing says that that is an appropriate way to respond to your dispute. So let's do a true or false really quick, y'all. I want to make sure that we are following, everyone is still engaged in the information. And so I just want to I'm doing these little things to make sure that you guys are retaining what I'm talking about. All right. The furnishers are supposed to conduct their own reinvestigation and send the agency that you sent the dispute to the results of that reinvestigation. And if they found an error, they're supposed to report that to all other agencies that they're currently reporting your account to. For true or false? True, true. Perfect, true. Yep. Yep, yep, yep. Perfect. Okay. So that was the FCRA, right? Fair Credit Reporting Act. Now we are going over the FDCPA. All right. Give me 1 second, y'all. Okay, so 15 U.S.C. 1692. It is the purpose of this subchapter to eliminate abusive debt collection practices by debt collectors, to ensure that those debt collectors who refrain from using abusive debt collection practices are not competitively disadvantaged, and to promote consistent state action to protect consumers against debt collection abuses. Now, one thing I love about the law is, especially consumer law, when you are reading these new subchapters, they are explaining to you why these things were created, so that as you are going into and diving more deeply into what's being taught, you have a better understanding as to what's about to go on further down the line. So if you all understand what was just said, you all will be able to understand that there is such thing as debt collectors who follow the law. Now, I understand that a lot of us have not come in contact with those debt collectors. And I don't even think I have, honestly. But there are debt collectors who follow what they're supposed to do. And in the event where they are not doing what they're supposed to do, you bring it to their attention, they fix it, and it's no longer an issue. So the FDCPA was created to protect those debt collectors, the very few and in between that exist, protect them, and to go after the ones who don't. And we know the ones who don't, man. We know Midland and LVNV, Resurgent, all them people. They don't do right, right? And the other ones that are the smaller debt collecting firms, they also don't do right. So this is for both of them. All right. Now, debt collectors are extremely simple to handle. And the reason for that being is that most of them never have the documentation to prove that they are supposed to be doing what they're doing. Okay? So that's a good thing for us. Sorry, let me charge my laptop on because it's so long down, y'all. My laptop kind of dies pretty quickly these days. But what was I saying? Debt collectors. They're extremely simple and easy to handle because they almost always never have their paperwork together. They are so sloppy. But the thing is that unfortunately, we have been programmed, our family has been programmed to, when they see a debt collector, run the opposite direction. They have been programmed, we have been programmed to be scared of a debt collector when they are trying to attack us or collect money from us. So because of that, these companies are multi-billion-dollar corporations based off of the fear of the people who they are going after. Can you imagine how many companies we would bankrupt if people learned how to fight back? People understood that if you just read the paperwork that's presented in front of you, you have enough information to fight back. And debt collectors are not hard to defeat at all. They're not. But because there is a stigma around debt collectors, every single year, every single month, they are able to get over time and time again on everybody. So the ones that are here today, I want you all to really take this thing seriously. 2026 is around the corner. I can't believe how fast time has flown by this year, but it just feels like it just started and it's already almost over. I want you all to really take what I'm teaching you all today and spread it around. Now, obviously, I don't mean, copy, my content and sell it and all that. I don't mean that. I mean, implement what I'm teaching you all. I want you to do your own research and your own studies on this information. And I want you to really apply it. And I want you to help people. I want you to continue on these practices because with us doing our part, we're able to change the world. And for me, that's more important than anything else. These debt collectors, these agencies, these furnishers, they are getting over on us so heavily because of the ignorance of people. And you can't help what you don't know, but it's up to us, the ones who do know, to provide the information to the ones who want to know. So I really want y'all to take this and fly with it. Okay. So just like I did with the FCRA, I'm going to get into some common laws that are broken by debt collectors that you all are able to get them for. All right. So this one, the first one, 15 USC 1692 CA. 15 USC 1692 C is communication. So it governs all communication as it relates to you and a debt collector. All right. So without the prior consent of the consumer given directly to the debt collector, or the express permission of a court of competent jurisdiction, a debt collector may not communicate with a consumer in connection with the collection of any debt. One, at any unusual time or place, or a time, place, wait, hold on. At any unusual time or place, or a time or place known or what should be known to be inconvenient to the consumer. Now I want to stop here. The reason why is that if you are not communicating with the debt collector, if you don't let them know that right now when they are calling you, it is an inconvenient time or place, they have no reason to know that. The same is true for your credit reports. Remember, I was talking about how if you don't tell the agencies that something is wrong, they're going to assume that it's accurate because they don't know. They don't have knowledge of the contrary, right? So the same is true for debt collectors. Instead of ignoring their calls, instead of blocking them, answer the phone and tell them, right now is not a good time. I would rather you call me between the time of, make up a time. All right. That's convenient to you. Because in the event that they call you or they reach out to you outside of that time frame, they have now violated the law. But like I said, if you don't communicate that information, there is no way to get them. Outside of that, they're following the law, right? So, furthermore, in the absence of knowledge of circumstances to the contrary, a debt collector shall assume that the convenient time for communicating with a consumer is after 8 o'clock in the morning and before 9 p.m. local time at the consumer's location. So they normally call, like, I may have heard maybe like one or two people in my entire time doing this that said that they have gotten like calls from debt collectors that are like after 9 o'clock. And so in that time, in that instance, that's an automatic violation because clearly it says 8 to 9, right? But they normally always call in between those times outside of that. And so if you know it's a debt collector, just answer the phone. And I understand why it's very scary to speak to them because you don't want that constant reminder that you are currently behind on bills. And so you would rather act like it's not reality right now. And so you ignore it. But the thing with that is that by you ignoring that situation, it gets worse. It may not get worse immediately, but eventually it's going to bite you in the butt because it could eventually turn into a lawsuit because you haven't responded and they've tried. So at this point, now you're being sued. It is just not, it's not addressing anything. It's not being productive about situations. So I understand that we all fall on hard times. I have plenty of times. A lot of you all know my story, so y'all know about the things that I've dealt with. I fell on hard times as well. But now that you have this information, answer debt collector calls. Now, what I want to tell you all is never, ever, ever, never admit to owing anything. They love to try to get you guys to, they love, because the issue with people is they don't know how to be quiet. I'm saying that in an extremely nice way. I don't mean to insult anybody, but we get so like amped up and riled up. And so our mouths are flowing, flowing, flowing. We're saying everything that comes to mind. So where you are going to be strong at is answering the questions that you're asked, right? So if they ask who you are, confirm you are who they are looking for if you are. Because if not, then nothing that I tell you to do afterwards is going to work. Okay? So if they're looking for you first name, you last name, yes, this is she, yes, this is he. Okay. Then after that you say, now is not a good time. Here's a more convenient time for me. And you can if you want to be a little, you want to be a little creative with it, you can give them a really short time frame, like between on Monday, Wednesday, Friday, I'm only available from 9 to 9:45 in the morning. And then on Tuesday and Thursday, I'm only available from 10:15 to 11:30 in the morning. Something like that. Like, you can be creative with it. Uh, sorry, y'all. Uh, uh, oh, so I'm currently on so for some reason TikTok just I'm on TikTok, y'all, so it messed me up. All right. I got
Did you lose your place?
huh?
Did you lose your place?
I did.
You were talking about giving them a shorter time frame, being creative and giving them a shorter time frame
Okay, thank you,
to
sis.
contact you. Yep, we got you.
All right. So yeah, if you want to be creative and do it like that. All right. Now, what this is doing is this is satisfying your requirement under this law. Now, also, this is a little jump for y'all because I actually wasn't planning on telling y'all this. So definitely do it if they are calling you. Now, I'm gonna get into the written part of things a little bit further down the line. We talk about the collection accounts. But for right now, if they are calling you guys, that's what you can do. You can also, when they're calling you, you can say, you can verify who you are, never admit to owing anything. So if they try to like slide it in like, you owe XYZ, I do not admit to owing this, but I am requesting for you to send me everything that you have on this account to my address. And you get them your address. Don't be scared to give them your address. They're not going to kill you or nothing. Like, they're just trying to send you information. So give that to them. And on top of that, so your steps are provide them with the time or place, and then you can ask them as an addition to send whatever they have to your address on file or to your address, your current address. Give them your address so they can send it to you. Right. And then we'll go into exactly what you need to do that they send it to you. We'll do that later on. Okay. So I'm not going to forget that because it's a part of our process anyway. All right. So before I move on, y'all, let me know in the chat, what are the things you need to be doing? So if I call you at the debt collector, ring, 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 what are you going to do? What are you going to say to me? Let me know in the chat. Answer first, verify who you are. Perfect. Okay, so now after we answer and verify who we are, and I say, so I'm calling about this debt that you owe to Capital One for $1,500. Are you willing to make a payment on that today? What are y'all gonna say? Ask for all documentation that they have regarding the account. Perfect. Answer, verify identity. Let them know that it's not a good time. Get them a time frame to call. Never meant to always / request info in writing. Perfect. Perfect. Don't say you owe it. Exactly. Perfect. Y'all are following. Perfect. Okay. So y'all know. I felt that that was important for you guys to kind of go through, because when like I want to say it was last year, like in the middle of last year, I was connected with this huge group of like what are they? Real estate agents and on Facebook. And so I was giving them my tips, right? I was telling them like answer the phone, verify who you are, and XYZ. And so all I seen, now mind you, this is a group of like 100K plus people. All I seen was people like coming at me like, you never verify who you are. What? That's so stupid. And like they were just coming at me, and I'm like, hold on now. Like, don't kill me. I didn't say, let me clarify. I didn't say you admit to owing them. I just say verify who you are. So I just want to make sure that I'm letting you guys know that it's not the same thing. You're not admitting to owing anything. You're just admitting that you are who they're looking for. Because if you're not going to admit that they are who they're looking for, then if you try to get them for violating the law, it's not going to work, because they have a recording of this call, right? So they can easily present to the courts. She told us that this wasn't her, so her case don't have any merit to it, and they're going to win because you at the very beginning said this is not you, this wasn't you. So your whole case just kind of derailed from there. So I just want to make sure that you guys understand that admitting or verifying who you are is not the same as admitting to owing them money. All right. Okay. So based on what we just went over, what we read, can a debt collector call you if it's between the hours of 8 a.m. and 9 p.m.? Yes or no? Yes. Yes, yes, yes. Okay, perfect, perfect, perfect. Okay. Our next famous violation for debt collectors. This is one of, excuse me, gosh. This is one of the most popular. So that first one I just went over, and then this one as well, most popular laws that the debt collectors always are violating. Extremely simple to get them on because they are just sloppy. Okay. Seasoned communication. So 15 USC 1692 CC. If a consumer notifies a debt collector in writing, so not on the call, guys, not in passing, in writing, that a consumer refuses to pay a debt, or that the debt collector or that the consumer wishes the debt collector to cease further communication with the consumer, the debt collector shall not communicate with the consumer further. I'm over here adding my own words to stuff. Okay, let's do this over. The debt collector shall not communicate further with the consumer with respect to such debt except these three things. So let me stop here before I go into those three things. When the debt collector calls you, you don't tell them, I'm not going to pay you, and think that they don't have the right to call you back again. Because the law says here that if you want them to stop calling you, you have to tell them in writing to stop calling you. All right. So, and how you tell them stop calling you is you say, I refuse to pay the debt. Now you don't, now I'm going to give you guys later on, when we're going over collections and how to deal with them, I'm going to give you the writing, the terms and the things you need to say to explain that. Because you don't want to just plainly say, I refuse to pay the debt, even though it says that, but you want to get a little bit creative with it, because debt collectors have been fighting back. And the reason why I've been fighting back, it's not like they have been that successful. But if you don't know like what we know, like especially what you guys are learning today, you don't know what you don't know, then they're going to win. Okay. So I want you guys to be a little bit more creative when you're saying that when you're refusing to pay the debt. Okay. But that's what you guys are saying. You refuse to pay the debt, or that a consumer wishes the debt collector to cease further communication. So you can say, I refuse to pay the debt, or I request that you cease further communication with me about this alleged debt. Once they get that letter in the mail, okay, or once they get that email from you, or once they get that text message from you, they should not respond to you at all again about that account unless they are going to be advising you that their further efforts are being terminated, or they're trying to notify you that they or the creditor may invoke specified remedies which are ordinarily invoked by such debt collector or creditor. So let's say for a vehicle, right? Let's say that a debt collector has acquired your past due auto loan, and you still have your vehicle. So you send them a letter says, I refuse to pay the debt. And so they should respond to you saying that this confirmation that we received your letter. We are not going to be trying to pursue this debt further, but please be advised that we are within our rights to invoke specified remedies such as repossession of your vehicle. That's something that's like an example, okay? They are supposed to let you know that. But nowhere should it say, oh, by the way, if you want to avoid getting this repossession, go ahead and send us X amount of dollars and we'll take care of it right now. Once they've done that, now they're breaking the law because you're trying to collect after I just specifically told you to not try to collect from me. Or 3, where applicable, notify the consumer that the debt collector or creditor intends to invoke such remedy. So if they was to say, that's fine, we're not going to try to collect from you, but just let you know that we're going to repo your car in 2 weeks. You know, like something like that. I mean, obviously that's not how they say it, but just to sum it all up, okay? So let's see. All right, so what do you need to do in order for a debt collector to cease collection activities? Let me know in the chat. Take a haul, y'all, because I'm struggling, y'all. I'm telling you. Let's see. We need to help them help us. State that I refuse to pay the debt. Exactly. Exactly. Okay, so send a dispute 50 USC 696 requesting them to cease all communication. Yep. And the great thing about this, y'all, is that you guys are gonna see you don't have to quote laws at all, like in your letters. So, like when I first learned about this information, and even when I was taking clients, I was like quoting all these kind of different laws in my letters and like trying to sound more sophisticated, trying to sound like a lawyer. And for one, it didn't make sense. Like when I learned exactly what those laws were saying, is like, what are you talking about? You're just saying like run-on sentences that don't even add up together. And so that's 1. 2, like they understand that we are not lawyers. They understand that we are everyday consumers, which is why they're trying to violate us the way that they're trying to violate us, right? So you don't have to appear to be somebody that you're not. You don't have to do that. You're an everyday consumer. And yes, everybody on this call is extremely educated. Don't get that twisted. I understand that. But I'm saying you don't have to try to sound like a lawyer when that's not your position. Okay? You're just a consumer. So let's just plain language is all you need to do. As long as, now what I have been doing is let me take you guys back to this example right here. So let's say that I want to use this one, or let's see. Okay. Let's say that I wanted to do a letter, right, in writing. And I wanted to tell them that I would rather them to call me between the hours of 8 and 9 a.m. Monday through Friday, right? Just make it simple. So if you wanted to use the law, instead of saying, according to 15 USC 692 CA 1, and then quoting all this, you would say, I have been receiving calls from your office, and this is an official notice that the only convenient time for communicating with me is during the times of 8 a.m. and 9 a.m. Monday through Friday. Any other times outside of this time frame that I just provided you is considered to be an unusual time or place that is also inconvenient to me. Boom. So you see how I really quoted the law, but I also added my own little flavor in that, right? So if I'm going to be using the law and using the words of it, just pick what pieces that are relevant, but you don't have to quote the statute. Like, you don't have to put the statute, the number. You don't have to do that. Does that make sense, y'all? Okay, good, good, good. Perfect. Perfect. So let me see. Something else I wanted to go over before. Okay, so 1 second, you guys, on here. I'm going to be now, let me go back to where I was. All right. Yep. So I'm going to be disconnecting with TikTok. So give me a second, y'all. All right, guys. So I know I had to get off of TikTok because you guys pay for this information. I didn't want them to know the sauce. Yeah, I gave them a little teaser. But you all actually are part of the movement. So I had to